Safe for Work and Pensions.
Yes, Mr. Bond.
My lady, my lords, good morning. Two notes ought to have made their way up to the bench. There is a short agreed note, of which my learned friends on the other side are the authors, dealing with the topic of birth certificates. There is then a slightly longer note, which I said yesterday we would provide. And what is in that? Paragraphs 2 and 3 address the question of who is subject to the SCR policy. Then paragraphs 4 to 7 address a question that was asked about what access to the SIS system is needed, whether access to the SIS system is needed when someone makes a new claim for job seekers allowance, to which the answer is not usually. And then paragraphs 8 to 17 pull together the various information which the respondent has provided at different times about the aims on which it relies to justify its retention policy. I'm hoping having pulled those together in a note will save me a bit of time this morning, though I am, of course, going to come back to the topic of justification later on.
Thank you.
Can I then go on to my third section, which is the effect of the Gender Recognition Act? And it may be worth momentarily revisiting section 9, which is at MS page 55. As the court looked at the relevant sections yesterday, I'm only going to point out a couple more details. The opening words of section 9, subsection 2, of course, state that anything which before the issue of a GRC was done in one gender is not deemed by virtue of the GRC to have been done in the other. And I just wanted to point out that that, in fact, chimes with the phraseology used in section 9.1, a section that works prospectively, as we can see in the use of the verb becomes. The person's gender becomes the acquired gender. What does the section do? Well, as my Lord Wilson pointed out yesterday, section 9 states the legal effect of a GRC. If one wishes to divine what statutory duties apply to the use of information, one has to go elsewhere. And in particular, can we go back briefly to section 22, which creates the offence of disclosing protected information acquired in an official capacity. And 22 is at page 67. Yes, I lied about that. It's page 65. And all that we want to add about section 22 is to underline that we rely on the defences under section 22, subsection 4. And in particular, the court has already looked at paragraph F, where a disclosure is for the purpose of preventing or investigating crime. In those circumstances, it is lawful for an official to disclose protected information. And perhaps more importantly, H, the disclosure is made for the purposes of the social security system or a pension scheme. In which case, once again, it's not an offence to disclose the information. Now, what paragraph H in particular demonstrates is that Parliament expected officials working in the administration of social security and pensions to come into possession of what is called protected information, and indeed to use it. Were that not so, I submit there wouldn't be a specific defence for it.
It's expressed in rather surprisingly broad terms, isn't it? I mean, there needs to be some sort of implied limitation, presumably, would you accept? And it's got to be, well, I suppose it's got to be directed to purpose which require the information within the context of the particular scheme in question.
Well, my lord, I suppose if an official were standing in the dock charged with the offence, the official would no doubt insist on the full breadth of the wording, and I, for present purposes, perhaps I wouldn't like to go behind it.
No, I see.
I wondered if I could also just point to the explanatory notes on the Act. If I can take the court to MS 129. And at the bottom of that page in the explanatory notes, there is comment on section 9. Paragraph 27 summarises subsection 1 and its fundamental proposition. And then 28, subsection 2 provides amplification of subsection 1, making clear that the recognition is not retrospective, so that the certificate does not rewrite the gender history of the transsexual person, etc. We say that's very clear. And further to that, where, by way of exception, Parliament in this Act did decide that history to some extent should be rewritten, Parliament stated that that's what it was doing. And for that, can we please, for an example of that, can we just go to MS 115? This is paragraph 7 of Schedule 5, dealing with benefits and pensions. I think my learned friends referred to it yesterday. And paragraph 7.1 says that certain questions about retirement pensions are to be decided as if the person's gender had always been the acquired gender. And the fact that it spells that out recognises the default position, which is that a person's gender has not always been the acquired gender. Drawing the provisions together, it's clear that the Act does not create a right to have one's previous gender effectively forgotten by the state social security system. And correctly calculating or verifying claims or winkling out frauds is not a failure to respect a person's acquired gender, and nor is the retention of data for those legitimate purposes. In terms of case law, such case law as there is, so far as we are aware, it goes entirely in the direction of acknowledging that history is not rewritten. In our case, we referred to the case of J and C, where the Court of Appeal held there was no lack of respect for acquired gender when the court in 2006 ruled that a couple's purported marriage back in 1997 was invalid because both partners had been legally the same sex at the time. The effect for the family was rather important. It was that the transgender male partner, who had since obtained a GRC and who at the time of the Court of Appeal hearing was legally a man, was not in law the father of a child born to his partner by artificial insemination in 1991. And I would submit that a ruling like that has much more of an impact on the father's acquired gender than any such use of data as is contemplated in the present case. Ms. Harrison yesterday took you to J and C and to Lord Justice Richards, paragraph 48, and it's the same passage that we both have in mind. Can I just take you to another reference in our written case, if you wouldn't mind going to MS 4302.
4402.
4302.
4302.
At our paragraph 64, we refer to the case of JK, where Mr. Justice Hickinbottom held that gender recognition, again, is not retrospective, because of the terms of sections 9.1 and 9.2, and as his lordship put it, to this extent, the principle that a transsexual should be able to keep private his or her gender reassignment bows to the principle that history should not be rewritten. Other relevant authorities are mentioned in the written case, and I don't go to them now. My lady, my lords, taking those points together, our submission is there's no merit in ground one. Can I then go on to the fourth section of my submissions, which starts work on ground two. And in this section, I would like to cover the nature and extent of the interference with Article 8 rights. Now, as I said yesterday, we have accepted that, to borrow the words of the Court of Appeal below, the systematic collection and storage in retrievable form of public information about an individual is an interference with her private life. And therefore we accept that the retention policy requires to be justified. And it's necessary to begin by measuring the extent of the interference, which I address now. Once I've done that, time permitting, I will say a few words about discrimination before then returning to justification and the key issue of proportionality. The description which I would invite this court to give to the interference with rights is that it's limited. And in saying that, I am not asking the court to overlook the particular sensitivity of historical gender data for a transgender person such as the appellant. Instead, what I do say is that the extent of the interference is measured not only by the sensitivity of the data, but also by what the respondent actually does with the data. One's got to look at both. And I would suggest that the real focus of this appeal has been not the mere presence in a giant database of a few lines of sensitive data. If retention were the real problem, well then masking wouldn't be put forward as the solution. But the difficulty with this appeal, the difficulty for the appellant, is that there's no evidence of data being used or misused in any way which positively interferes with her rights. Now, the Court of Appeal analysed this, and my learned friends criticised the Court of Appeal for making comparisons with some of the police data retention cases like CAT or S and MARPA. We can agree that the present case is not on all fours with the police cases, but the courts below didn't say that it was. I submit, however, that those cases are helpful because they identify the types of factor that are relevant when one assesses whether there's an interference and, if so, the nature of it. So, for example, the Court of Appeal was entitled to note that the inclusion of Mr. Cat on the police's domestic extremism database was found by the Supreme Court to be only a minor interference with his personal life. For the court's note, that's Court of Appeal, paragraph 56. And the court below was also entitled to note, drawing a comparison with S and MARPA, that whereas a person would not normally share their fingerprints and DNA with anyone else, a person's gender history would almost inevitably be known to some other people, however closely guarded a secret it might be to the world at large. And the Court of Appeal, I submit, was right to have regard to the fact that if the gender data in this case comes to the attention of anyone, it will be to an official for the purpose of carrying out professional duties. On that, I wonder if I could go for a moment again to the case of J.K. This is Authorities 34 in Authorities Bundle 5, and it's MS 1336. In JK is the case in which the interference consisted of requiring a transgender woman to be identified on her children's birth certificates as their father. And I just wanted to point out that in that case, this factor, namely that disclosure of data would most likely be to an official doing his or her job, was considered material. May I take you to page 1362, paragraph 89 of Mr. Justice Hickinbottom's judgment. Sorry, I've gone one paragraph, a couple of paragraphs too far. Can we take it, please, from 87 on the previous page? What his lordship here said was that he accepted that from time to time the claimant and her children would be likely to be required to produce these offending birth certificates. However, the number of occasions when such production will be required will be relatively rare, and almost exclusively the production will be to people who receive the information in an official capacity for the purposes of Section 22. The judge then noted the potential criminal offence of disclosure, and the judge regarded it as almost inconceivable that officials would disclose such information. And he went on to say, the occasions when the claimant and or her children will be required to produce a full certificate to someone other than a person in an official capacity will be very rare indeed. And if I can then go on to the next page, and in particular to 89. Therefore, whilst I accept that the requirement for a person in the position of the claimant to list herself on the birth certificates of her children as father interferes with her and their Article 8 rights, both conceptually and to a limited extent in practice, I consider Mr. Jaffe's submission that in all the circumstances the interference is not material to be very forceful. And I submit there is a direct comparison to be made in this case when one asks the key question, what's actually being done with the information? And to that I add one more factor, that the carrying out of an official's duties, for example, to further a benefits claim or to verify the appellant's identity or to prevent her identity being stolen, is highly likely, if not certain, to be for her benefit. And whilst she might feel uncomfortable about her data ever being used by anyone, it should be borne in mind that it's impossible to imagine a situation in which it's not being used for her benefit. And there one must contrast cases about retention of things like people's previous convictions or police cautions, which effectively could only be used to their detriment, for example, by disclosure to protective employers. The case of T and Chief Constable of Greater Manchester is an example. That was authorities number 26. Now, on top of that, the fact is that, as we've seen, the information is securely guarded, and access to it is tightly controlled and audited. If access is abused, people are disciplined, as well as being at risk of criminal sanction. And those facts may no doubt explain why, in reality, this challenge is really directed at, or at least fueled by, the SCR policy. So what, if any, interference with rights does that policy cause? Well, my first submission is that one has to take the effects of the SCR policy as a whole. I mentioned yesterday the agreed fact that the policy is designed to ensure fuller protection for sensitive information. And I asked the court to remember as well that it is the SCR policy is accompanied by other supporting policies and rules. There is user guidance. the DWP has a more general standards of behaviour policy and so forth. The references are in our written case. The Court of Appeal said that the fact that the policy is intended to benefit the appellant is not an answer to the Article 8 challenge. We don't disagree. But we do say that protection of customers is not just an intention, it's also an effect. And I further say that given the choice made by the appellant and most transgender customers to remain within the SCR policy and not opt out of it, that makes it very hard for them to argue that the policy is not, in fact, providing enhanced privacy protection, whatever disadvantages it may bring with it. That's essentially why we say the Court of Appeal was right to reject the submission that in its protective role, the SCR policy doesn't go far enough. But the second complaint about Article 8, as recorded and ruled upon by the Court of Appeal, was that SCR leads to delays and, worse, draws officials' attention to transgender customers. I addressed you at some length yesterday on the outing point. So far as the impact of delays is concerned, we respectfully adopt what the Court of Appeal said about that, and I wonder if I could go to that for a moment. It's Court of Appeal, paragraph 68, MS 4546. Paragraph 68, we say Lord Justice Elias was right to say that some delay is inevitable if access to information is to be authorised. SCR customers on the evidence are not the only customers to experience delay, and within SCR, everyone who's subject to SCR equally experiences the delay. Administrative failings may be a matter for complaint, but in our submission they don't infringe Article 8. Putting these points together, we submit that the Court of Appeal was right to take a measured view of the interference. We invited the Court of Appeal to characterise it as minor, and the Court of Appeal did not accept that invitation. You'll find that in the judgment at 56 and 57. They said minor was to understate it. But what I say one takes from the judgment as a whole was a finding that it was limited in the sense of being less serious than the types of intrusions seen in other reported cases about data retention. Now, I said at the outset yesterday that this was where I would refer to the material put in by the intervener, and I propose to do so very briefly indeed. The intervener's written case does not contain any legal submission which is different from the appellant's case. What it does is tell us who the intervener is, and the fact that the intervener considers that relevant data ought to be masked. And so the intervener supports the appeal to that extent. And the court will be aware, of course, that a number of witness statements were attached to it. And my submission in summary about those is that none of them should change what I've just suggested as the court's assessment of the interference with the appellant's rights. Two witnesses, GB and NW, give evidence of experiencing delays, and in my submission, they add nothing to what has already been admitted about delay. There is a witness called CP. I won't ask you to turn it up, but the MS page references is 4418. And it appears from that statement that that witness is not an SCR customer. What the evidence seems to be about is about the treatment of that person's change of name and change of gender in the absence of a GRC. And my point is simply those facts are not really what this appeal is about. There is then a witness called TW at page 4421, who refers to an incident in August 2014 when a DWP employee telephoned her and, she says, effectively accused her of committing fraud. The incident as described consists of an employee not knowing, and therefore not believing, that a change of name and gender had taken place. My reply is that that doesn't reflect any DWP policy or indeed anything that is at issue in the appeal. A complaint about it is still pending to the independent case examiner. We can't be sure what happened, and we certainly don't know the reason for whatever happened. And then finally...
could you just, on the CP, the one before, can you give me the reference in the core volumes, I mean the hard copy volume?
I can, if
don't worry, someone can help
assist me to do so. While that's being retrieved, can I finally comment on the witness who
I think I've got it in the core volumes.
Great, my lord. Of course, it's in the core bundle,
Yes,
as Mr. Payne's reminded.
Thank you.
Finally, there is the witness who I believe can be named, although his initials are JM. He covers two main points. First, he says that reports of hate crime have considerably increased. And it's acknowledged that there is a very serious problem of hate crime. We don't know whether the reported increase is an increase in crime or an increase in reporting. The hope is that people are feeling more able to report that sort of crime than they once were. His second point is that he refers to a recent survey about customers' experience of the SCR system. Now, this evidence emerged a short time before this hearing. My clients haven't been able to explore the substance of it. But what we note about it is the use of a questionnaire. For the court's note, it starts on MS 4401, a questionnaire which invites respondents to criticise SCR and indeed offers up specific criticisms of it for them to adopt if they wish. Apart from the leading nature of the questions, we are not in a position to assess the reliability of the responses. But again, to harp on a particular theme of mine, we certainly don't know that SCR is the cause of the negative experiences that people complain about. We would readily accept that where what they complain about is delay, that we know about. But where people say, well, my old name has been used, I've been spoken to rudely, etc. Well, as I've repeatedly said, we just don't know why those things have happened if they have. One reason for that is that the witness in his statement, it's his paragraph 24, says that the customers, quote unquote, nearly always don't make a complaint. And that reluctance may be entirely understandable, but unfortunately, it makes these complaints unverifiable. Finally, that witness also refers to delay, and he says that in his survey, some 37% of respondents complained of delays. Well, my clients will be the first to say that all delay should be avoided, but it's nevertheless encouraging to hear that even of those who had requested gender change and who responded to the survey, 63% did not complain of delay, so it does not all go one way. What I would, however, just ask the court momentarily to look at is the witness's conclusion on page 4399. He feels that the policies are damaging and discriminatory and that SCR does not provide adequate protection and it imposes burdens. The Equality Network considers it unacceptable that, that the SCR system restricts trans people's records from standard access Basic computer database technology should be used to allow standard access to the file with only the person's current name and gender identity to be seen by frontline staff. If the court considers it necessary to retain historical data, I think it says, gender reassignment data, that data should only be accessible by DWP, fraud protection officers, and/or for the purpose of calculating pensions. Well, our response to that is that that desired situation is not a million miles from the actual situation, which is that, as we said yesterday, routine access by frontline staff does not reveal protected information. Protected information is only accessed for good and proper reason. And for those reasons, my submission is that the intervention, nothing in the intervention will affect the outcome of this appeal.
Could I just...
Why should it be any number of miles from the...
Yes, that's a million.
My Lord, probably the most technical answer to that question is the respondent's margin of appreciation. And I'm going to come to this on justification, because what we've done is sought to pull together the explanations of why the data is held in the way that it is. When I used the metaphor, not a million miles from, what I meant to say was not materially different from. And what I would suggest is if one sat...
Well, that provokes the same question. Why should it be different at all?
Well, if the difference isn't material, then in my submission, it's highly unlikely to...
You'll come to this justification, but...
My Lord, I will.
Obviously, the least intrusive means looms large in this picture, but...
My Lord, I accept that it does, and
we'll debate that later.
I've got to deal with it. What we can see from that conclusion in the witness statement is, well, what we suspect from it is that the witness may not, in fact, have a complete knowledge of how the processes work, because if he did, he might not have made his point in terms which sound really so close to what the true situation is.
It's developed over the course of these proceedings, hasn't it?
It has developed, my Lord. I'm not criticising the witness. But what I say is that if the witness himself is in no way expert in how the systems work and what they attempt to do, well, then one should give only limited weight to the fact that he expresses discontent with some limited differences between what he would like to have happen and what does happen.
Can I just pick you up on one point? The CP, which was the one you made the point that he or she wasn't on the SCR, or didn't appear to be on the SCR system, and you seem to think that made it less relevant. But surely, to some extent, we are concerned with the... I mean, part of your case is that the basic sort of CIS JSAP system actually is pretty unobjectionable, or is materially unobjectionable, whatever word you want to use. And insofar as the SCR system creates difficulty, well, people can opt out of that. So to the extent that we have someone who isn't in the SCR system, that may illustrate the problems there are with the basic system. Is that a fair comment?
It's difficult to answer without knowing the facts about CP's case. And one possibility that's on my mind is the perhaps obvious one that CP ought to be in the SCR system. And if, in fact, her experiences have been negative and have given her a feeling that her data aren't being properly protected, then I would draw attention to the fact that there's a policy in place by which they should be. It may be that CP, if everything she says is right, is another person in whose case something's gone wrong. But what in my submission CP doesn't identify is that there is a specific policy of the respondents that is unlawful in a specific way.
Thank you.
May I now turn to discrimination, which I will try and take concisely to leave more time to talk about justification. Starting with direct discrimination, yesterday I invited the court not to entertain the argument because the appellant's case clearly is, if anything, a case of indirect discrimination, and as I said yesterday, it can't be both. This morning I will add only 2 points to that. First, most fundamentally, the allegation of direct discrimination is misconceived because the SCR policy operates neutrally as between the transgender and non-transgender individuals who are in it. There is no less favourable treatment of the transgender people. And the second point I add is that the direct discrimination claim can't be brought within the Equality Act 2010 because the appellant has demonstrably failed to identify a comparator. That's either a real or a hypothetical one. We go into this in some length in the written case, so I'll take it briefly. Section 13 of the Equality Act requires a comparator. We say the only conceivable candidate to be that person would be a non-transgender customer to whom the SCR policy is applied. However, the appellant's written case, in terms, it's their paragraph 109, rejects that person as the comparator. That person can't be the comparator because their circumstances are materially different. And we say, a fortiori, the same must be true of any other non-transgender customer, i.e. a non-trans customer who is not in the SCR policy. So how does the appellant maintain the argument? Well, my learned friends seem to suggest that no comparator is actually required. And the case that a case they refer to for that is Shamoon and Chief Constable of the RUC. I'm not going to take the court to Shamoon, but I simply leave with you the submission that nothing in the Shamoon decision relaxes the statutory requirement of a comparator, and the direct discrimination claim simply doesn't work. I then turn to the alternative formulation of direct discrimination, which takes the form of harassment. And I said yesterday that it would be unfair to allow the appellant to rely on harassment for the first time as a cause of action in this court. But in any event, the proposed harassment claim is without merit. My learned friend's written case makes clear that the alleged harassment consists of outing, and the court has our factual submissions on whether either of the policies has the effect of outing. But even if it does, the harassment claim still doesn't work. Can I take the court for a moment to Section 26 of the Equality Act, which is MS 153. Or authorities number 3. Section 26 says that a person A harasses another B if A engages in unwanted conduct related to a protected characteristic and the conduct has the purpose or effect of violating dignity, etc. And at 26 subsection 4, in deciding whether conduct has the effect referred to of violating dignity, etc., each of the following must be taken into account: B's perception, the other circumstances of the case, and whether it's reasonable for the conduct to have that effect. The point I make is from section 26.1, which is that the unwanted conduct and its effect are two separate things. The appellant is clear enough that the effect complained of is outing. If that's so, then what's the unwanted conduct? The conduct appears to be applying the SCR policy, but what we say about that is the SCR policy is optional and the appellant has opted in, and for good reason, and therefore whatever criticisms one might level at the SCR policy, applying it is not unwanted conduct. Of course, if it... Oh, Lord, I'm
Let
sorry.
me just understand that because the appellant has opted in, does that mean that she has given carte blanche to every element, or she must be taken to have given carte blanche to every element of the SCR?
It means that the application of the SCR with its advantages and disadvantages isn't unwanted conduct. I accept...
Surely it's open to the appellant to say, well, I want to opt into this policy because it has advantages for me, but I certainly don't want to submit to the disadvantageous elements in it. And to that extent, it's unwanted conduct.
Well, the reason I say that doesn't work is that one can't break up the SCR policy. If it was a policy in several pieces and the DWP said, one, we will apply the protections so that the computer will go beep and people will have to be authorised, and two, we will then subject you to delay, and separately, three, we've decided that we'll draw unwanted attention to you, well, then an appellant might have a shot at saying that 2 and 3 are unwanted conduct. But my submission is that analysis is unreal. The conduct is simply the applying of this protective process, and sadly, we've not yet found a way to do so without the attendant disadvantages. And that is one of the reasons why in my submission harassment can't get off the ground. What we have heard about is that employees have or may have misbehaved. And as I think I said yesterday, if that's happened, it's a breach of the policies. It is not a part of the policies. Overall then, my submission is that the application of the protective policy cannot be said to violate the appellant's dignity or create an intimidating, etc. Environment. But if that contention itself is disputed on the facts, I note for one final time that harassment has come in very late in the day and the respondent has not been given a real opportunity to adduce evidence of it. And there is, of course, also the further test of whether it is reasonable for the appellant on the facts to regard the conduct as having that effect. Our written case cites the authority of Richmond Pharmaceutical on that. These are all matters, in the end, which we have not had a proper opportunity to explore. May I then come on to Article 14 and Flimenos. The appellant's case is that whereas she gets the same treatment as all those to whom the SCR policy applies, she ought to get, or must get, different treatment from the non-transgender people to whom the policy also applies. The simple answer to that is that everyone to whom the SCR policy applies has the same need, namely to have their sensitive information protected. Of course, the nature of the information will vary from case to case. For one customer, it may be a name. For another, an address. For another, it may be gender data. And equally, the consequences of any failure in the protection, consequences of an unauthorised disclosure, will vary from case to case. But my submission is that Article 14 does not require there to be a separate policy for every customer. My learned friends, of course, don't say that it does. They say what's needed is a separate policy for this category of customer. To make that good, they would have to show differences between the needs of transgender and non-transgender customers within SCR that have that requirement. And they suggest 3 such differences. Again, for the court's note, it's their written case, paragraph 93. The first is the effect of Section 9 of the GRA. They say that makes a difference. And on that, I just direct the court back to what I said this morning. And the second and third, as I read them, are two different ways of saying that the policy has the effect of outing transgender customers. And again, I addressed that topic yesterday. I therefore submit that the courts below made no error in relation to Article 14. Mr. Justice Simon was right to say that it adds nothing of significance. And he's right, because if the appellant wins on Article 8, well, Article 14 adds nothing. But if any interference with Article 8 rights is justified, we've not heard any coherent explanation of how the Article 14 case could somehow defeat the justification defence. And that point, rightly, I say, was decisive in the Court of Appeal for the Court's note, paragraph 72 per Mr. Justice Elias, Lord Justice Elias. And finally, on discrimination, I come to indirect discrimination under Section 19 of the Equality Act. And on that, I say that any difference, any technical difference between Flimenos and Section 19 will not affect the outcome of the case. The question won't arise unless the court finds that the policies have a discriminatory effect. That's the first hurdle. If it does, then the difference will matter only if the respondent can justify the policies in general terms despite their discriminatory effect, but at the same time cannot justify their discriminatory effect on the appellant. And perhaps unsurprisingly, the appellant has not articulated any analysis which could lead to that rather improbable combination of conclusions. As my Lord Carnwood said yesterday, when the essence of the Article 8 case is that you can't make these impositions on transgender people because of their transgender status, it's hard to see how running a separate discrimination, statutory discrimination argument makes a difference to the overall outcome. Moreover, under Section 19, the appellant has to show that the provision, criterion or practice, affectionately known as PCP, of which she complains, is applied both to people with the protected characteristic, gender reassignment, and to people without it. And that means that the comparators, again, must be people to whom SCR applies who are not transgender. And that leads us precisely back to where we were a minute ago under Article 14. Under Section 19, the appellant has to show why the policies, has to show that the policies subject her to a particular disadvantage compared with those other SCR customers. She attempts it, for your note, at paragraph 115.3 and point 4 in the written case, and once again it is the allegation of outing. It can't be anything other than outing, because delay and the attracting of unwanted attention are side effects suffered by all SCR customers. The court has my submissions about outing. And finally on this, it's not the sort of indirect discrimination claim where statistics help. It's not a case in which statistics help to demonstrate the particular disadvantage, and the reason for that is the pool for comparison, as I said a minute ago, consists of all those who are in the SCR policy. If I'm right that the SCR policy does not out transgender customers, then the pool, in this case, does not contain an advantaged and a disadvantaged group. Everyone in the pool suffers the disadvantages. And that's why there's no point in comparing the gender identity of advantaged and disadvantaged groups to check for disparate impact. If I am wrong about all of this, and there is indirect discrimination, then the respondent, of course, relies on the defence of justification to which I turn in a moment. But in relation to discrimination, I wonder if we could just momentarily go to the conclusion of the Court of Appeal at MS 4547. At paragraphs 74 and 75. I won't read those out. In my submission, in those paragraphs, the Court of Appeal comes to precisely the right conclusions about indirect discrimination. May I then move to my final section, which is justification. There may be some limited difference between the legal tests for justification which one applies, on the one hand, to infringement of ECHR rights, and on the other, to discrimination under domestic legislation reflecting EU rights. My submission is that, on the facts of this case, any such difference won't affect the outcome. In relation to human rights, to Article 8 or Article 14, we have the 4 Bank Mellat questions, to which reference was made yesterday. Is the objective of the measure sufficiently important? Is the measure rationally connected to the objective? Could a less intrusive measure have been used? Is the impact disproportionate to the likely benefit?
I always feel rather sorry for Lord Wilson when people refer to those as the Bank Mellat questions, given that Lord Wilson articulated those in Aquila sometime previously.
Very nicely said, but I'm not too upset about it.
Well, for the rest of my submissions, I will refer to them as the Aquila questions. In respect of indirect discrimination under the Equality Act, the way Section 19.2d puts it is whether the PCP itself is a proportionate means of achieving a legitimate aim. But we know that the Aquila questions apply to that test as well, and the authority for that is the case of Astor Communities, which I won't turn up now, but it's authorities number 88, paragraph 28, per, I think, my lady.
Might have been.
Whichever test is being applied, the respondent now relies on the pursuit of 2, it says, legitimate aims. Until the High Court judgment, we also relied on a 3rd, which has fallen by the wayside, and which I won't go back to. Can I first of all show the court how we put it in our summary grounds right at the beginning of this judicial review? Those are at page MS 4629, Appendix A, page 42. Can I point, please, to paragraph 8 of the summary grounds? It seems a long time ago that I wrote this, and indeed it was 4.5 years ago. They date from December 2012. What this tells us, I submit, is that contrary to what was suggested yesterday, the fraud aim actually was the first one that we articulated. It was suggested yesterday that the fraud aim is perhaps an afterthought. And if we could then go forward 10 pages to...
The aim to assist in planning and developing policies and so on, is that still part of the...
No, that's the one on which we lost before Mr. Justice Simon, and it has not been revived on appeal.
So which page do you want us to go to now?
Can we then go to MS 4639 or A53? And this is the detailed grounds following grant of permission for judicial review, these dating from April 2013. And once again, it's paragraph 8. There are the three aims at A, B, and C. C has fallen away. A is the pension claim, the pension's aim. I won't take you to Mr. Gilks's witness statement, but the pension's aim is set out in the point referred to. Now this, at least, is how the respondent justifies the retention policy. In relation to the SCR policy, of course, our case is slightly different. We say that SCR is justified as a privacy protection, and if its effects engage Article 8 at all, which we do not concede, then its negative effects are justified by its positive effect, namely the protection of the customer's private information. If I then come on to legitimate aims, whether the legitimate aims are sufficiently important to justify impinging on a protected right, and whether they are rationally connected to the measures in question, can I turn, please, to the note which we handed up today?
I'm sure that Lord Kerr will be asking that you supply it in electronic as well as hard copy.
If I don't ask, I'll expect.
It will be done. Can I take it, please, from paragraph 7 onwards? Where we make the submission that visible retention of data is and remains necessary for and justified by both of the surviving aims, fraud and pensions. And then under the fraud aim at 8, we would like to emphasise that in the early days of this claim, the relief being sought was the removal rather than the masking of gender identity data. And we've included a reference to the appellant's grounds, which I won't ask you to turn up now. But that is the reason why the evidence adduced by the Secretary of State, certainly during the judicial review phase of this claim, was focused primarily upon the need for retention of the data per se, rather than on the particular need for visible retention. As paragraph 9 explains, the evidence on the fraud aim was contained in the statement of Mr. James, who works for my client's Central Criminal Investigation Service, and that is a team responsible for the investigation of, I suspect, inter alia, potential identity fraud. Mr. James expressly resisted the temptation to go into too much detail about how frauds might be committed for fear of coaching anyone in that art. But he set out how fraud could occur in principle, gave some examples of past events, and said why the retention of the data is needed to reduce the risk of fraud. And it is my client's considered view that at 9A, without a record of previous name and gender, it would be easier for a person to steal the previous identity of a person with a GRC, which could then be used for fraudulent purposes. That's Mr. James. Mr. James also makes the points at B. A fraudulent benefit claim could be made by acquiring the original birth certificate of a person who has changed name and gender and getting an NI number allocated to the original name. So it's necessary to have information about the previous identity of such persons to prevent such fraudulent attempts to claim benefits in an old identity. There were the two examples from the year 2012. And at D, if historic gender identity data are not retained at all, there would be an increased risk of fraud. And at E, he explained that frontline staff were involved in the prevention and detection of fraud. I'm going to come back to that fact in a moment.
Well, 9A to D are all to do with retention rather than masking, is that right?
Yes, at that stage it is primarily directed at retention, although in my submission, if one explores the sorts of scenario and considers how potential frauds might be investigated, I submit one always comes back to the conclusion that at least some people need to be able to see the data. But may I work my way around to that? At 10, you will read that following the High Court judgment, the parties engaged in lengthy correspondence. They had hoped to reach some sort of compromise. And one thing that fueled that hope was the fact that the GRC held field did come to be masked. My learned friends yesterday rather implied that this revealed some unreliability in what my clients said about the cost of doing things like that. In my submission, it didn't. My clients, under their duty of candour, informed all parties that there had been an important change in their IT provision arrangements, which unexpectedly enabled that particular change to be made at a small fraction of what would once have been the cost for it. And at the same time, in this correspondence, my clients explained that the DWP did not consider that it could remove or mask name or title history because this would have a detrimental impact on the prevention of identity theft and fraud. Perhaps we should go to that page reference, MS 5320. And may I take the court to the heading, Consideration of Other Changes to the CIS.
This is April 2015. Yeah.
My lord, yes, it is.
24th of April, 2014, I think. Is that right?
Well, there's a letter on, wait a minute.
15.
15.
24th of April 2015.
Yeah.
5317 it starts.
So this is after the first court, before the Court of Appeal.
My lord, precisely. And under the heading, Consideration of Other Changes to the CIS, we read in the second longer paragraph that the department doesn't consider it can remove or mask name or title history, as this would have a detrimental impact on the prevention of identity theft and fraud. As is explained in the DWP's evidence, historic name data is frequently used to enable identity verification activities to be undertaken when a customer accesses a government service. And the paragraph goes on to deal with other practical impediments and cost. Now, what happened next, procedurally speaking, was a Part 18 request for further information. And again, rather than taking you to the request, can I take you to the response that was given to it? Part 18, further information verified with statement of truth. And we list at our paragraph 12 of our note what the response contained, namely some explanation about the £1 million estimated cost of masking historic name data, and then the need for frontline access to data in the response to question 6 on MS 5328, if we can just go there for a moment. Your Ladyship and your Lordships will read what is said in that single paragraph.
Sorry, which paragraph are we on?
This is the reply to question 6. We're on page MS 5328.
C132.
Are you on 5328?
No.
Sorry, 5328, yes.
Yep, it's got the reply to question 6.
Yeah.
Where's this?
Yes.
And may I then take the court forward to page 5331, please? And in particular, question 11, directed at visible retention. And there is a 3-paragraph answer, which you can see there and which is also indeed set out in our note. The appellant's representatives are a tenacious team, and correspondence continued. Can I show the court a further letter that my clients wrote at MS, an extract from it in MS 5357?
I haven't got these numbers. What's the other one?
I'm so sorry. It's Appendix 2C
Yes.
830.
Thank you.
This is set out in your note, isn't it?
My lord, it is.
I'm sorry, just give me the MS number again, please.
Sorry, I'm being told it's
5357.
827.
5357.
57.
5357.
5357 on the memory stick.
Thank you.
Question.
Sorry, my 8th... Oh, sorry, that's D1. 2C830.
Try C161.
161.
C161.
C161, is it?
61.
Yeah, okay.
That's what it says at the top.
Yeah.
It says 829 at the bottom.
Okay.
Any assistance?
Thanks.
161.
161.
161. Thank you.
Sorry, I should have been able to make it
last
easier
page
than
of
that.
No, it's your note has got the wrong reference, that's all.
Yep.
This is 30th of October.
30th of October 2015. And again, I won't read out the passage. We've quoted it for you in our note. While I'm on our note, may I then just skip forward to the last page, paragraph 16 and 17?
I mean, can we this is, as it were, the state of the evidence, is it?
It is.
I mean, we had sort of witness statements from people like Trish Lillian, but they were, in a way, a sense, been overtaken by all this.
Well, they've been supplemented.
They're supplemented.
We've
Yeah.
been asked to explain them
Yeah.
further, and what
But
you've seen is
for-
what came back from the
The
DW.
only witness statement dealing with the fraud aspect of it is Mr. James, isn't it?
Only Mr. James deals directly with it. There are references in the others, in particular to the subject of identity verification.
Yes.
And I submit there's an overlap between
But
identity.
there's also a part of your case, I think you make clear, is the sort of margin of appreciation that having identified the objective of dealing with identity theft, there's then a question about how practically you do it and what it costs and so on. And that was covered by, I think, Miss Lilly.
Yes.
But that is now supplemented by this.
Supplemented what is by what is read here, and I would like to come back to margin of appreciation in a moment or two.
Just before you move on, as it looks as if you're about to pensions, do you want to say anything at all about the suggestion that the references that you've just given us, 5320, 5328, 5331, 5357, are inconsistent, it is said, with 5277, which was an earlier response to a question? Question 18 on 5277 is where we were taken yesterday.
I'm being reminded that we have said something about this on page 5 of our note.
Thank you.
In footnote 9.
Sorry, I hadn't found that. Yes, you have.
The point being then that saying that masking wouldn't stop the central criminal investigation people from doing their work isn't the same thing as saying masking would not impede our objective of being alive to frauds, picking them up and so on.
Spotting them in the first place.
Yes.
I see.
Yes, I was just going to touch then, if I may, on the very end of the note at 16 and 17, where we mention the pensions aim. And aside from reiterating the agreed fact that data are needed for 1/3 of the transgender customers and will be for the rest of the lives of those people, but on top of that at 17, we go on to add that the need for visible retention of the data is necessary, notwithstanding the masking of the GRC held data. And we've given you a reference to a footnote in our case, which perhaps we should look at 4317.
Sorry, could you give me that?
Yes, it's MS 4317.
4317, yes. Yep.
And it's a reference to written case footnote 103.
Yes.
Where there are some examples of why data might be needed, even though the GRC field is now marked. We hope that that adds something to the sum of understanding as to how these processes work. This might just be a moment to remind the court, of course, that this issue was conceded below, and we are now resurrecting it in the Supreme Court and drawing together certain strands of information which, for quite a large part of this case, lay dormant because we didn't think they were going to be needed anymore. But they are what we have.
What, the issue of legitimate aim?
Yes, whether the aim's legitimate and whether it's rationally connected to the measures. As to rational connection, then, the appellant makes 2 points. She says that she is not one of those customers whose state pension age is affected by the GRC date. And second, she says visible retention of the data must now be unnecessary because GRC data have now been masked. Well, one short answer to both of those points is that if the information is needed for the fraud aim, then one doesn't get very far by picking holes in the pensions aim. But a second and more substantial answer is that I would submit there's nothing irrational about collecting a standard range of data from all customers because particular items of that data will, in any cases, be relevant to some of them. I'd ask the court to remember that the relevant IT systems have been in existence for years, and in the courts below, the respondent relied on evidence about the practical difficulty as well as the cost of making changes to them. And as I submitted in relation to discrimination, it is reasonable for the respondent not to have bespoke requirements for every individual customer, and in this case, not to have bespoke requirements for a subcategory. And on the appellant's second point about whether name and gender data are needed, I referred to that in our note just now and pointed to the reference for that. In their attack on the fraud aim, the appellants put forward a sequence of arguments that will be found in their written case, paragraph 64, all but one of which could have been advanced in the Court of Appeal but weren't. The only new one is the suggestion that frontline staff don't need to see the data because they will no longer see it after universal credit comes in, and I'm going to come back to that shortly. All of the other points overlook the fact that the respondent's case about the fraud aim is really rather straightforward. It's not intended to be a very complicated or sophisticated argument. And we submit that it was absolutely correctly summarised by Mr. Justice Simon in a passage which I would ask you to go back to, if I may, at MS 4563. At the bottom of that page, Mr. Justice Simon at 68 refers to the fraud and the fraud aim, the aim of fraud prevention and account verification. At paragraph 69, His Lordship explained how it was supported by Mr. James's witness statement. At 70, he records the concession, way back at that stage, that gender change data might be needed for these purposes, but that the GRC information could be masked. Well, of course, it has been. And finally, at 71, the acceptance of our argument that reduction of the risk of fraud is a factor which can properly be relied on and was properly evidenced. I invite the court in the end to adopt those conclusions. In summary, it's not surprising if changes of name and changes of identity are fertile ground for identity fraud, and it is the considered view of the respondents' experts that access to the various items of information is necessary to prevent fraudulent attempts at making claims, and there is a rational connection between the aims and the policies. Moving on then to the question whether could a less intrusive measure have been used, and then after that, overall, is the interference disproportionate to the benefit? As we know, the only less intrusive measure that's been suggested is that the offending data might be masked. And in addition to what we've said, about fraud and to what we've said about pensions, I'd also remind the court that the respondent's evidence was and is that historic name data are, in some circumstances, made available to some interfacing systems to support account maintenance, and therefore masking them would be a relatively complex exercise requiring a significant number of processes to be enhanced or changed with impact on a number of other systems. I'll just give you the reference rather than going to it. It's the second witness statement of Ms. Lilly, paragraphs 25 and 26, Appendix B, page 343, MS 5166. The estimated cost, as the court will remember, is in the region of £1 million, with even a feasibility study costing £25,000. The appellant, as I said, has not gone into, and perhaps hasn't been able to get into any detail about what a proposed masking scheme would be. But I'd submit it's not surprising if even a feasibility study might be quite complicated. It would have to address issues like what marker would remain on the system to enable information to be accessed when it needs to be. How would it address the question of whether a customer's data entry showing a name with a recent start date but no previous name might not itself reveal a gender change and might be offensive? Would there be a practical problem of unnecessary references to the investigation team arising from conundrums about names which couldn't be readily resolved because of the lack of visible data, and how that might be mitigated? What would the system do about customers who, sometime after their GRC, have a second change of name, for example, because of a marriage? Would the system block that sort of changes? How would one work around that sort of thing? Now, it's on this sort of practical and operational issue that I respectfully submit that one must consider what margin of appreciation should be accorded to the decision maker. As the Court of Appeal said in its paragraph 62, the respondent is entitled to have regard to other demands on its resources when determining the extent to which it should use its funds to prevent what we have said are limited interferences with Article 8 rights. I submit this is not the situation the court found in O'Brien of discriminating in order to save money. And furthermore, it's not just about money. It's about the difficulty of doing it. The reason why it costs a lot of money is that changes to parts of the system compromise other parts of the system. No doubt that is how the IT experts earn their fees. Now, in my submission, by contrast with the respondent, any court is not well placed to second guess decisions of that kind. And of course, as a matter of law, if the law does accord a margin of appreciation, it's not enough for courts merely to state that they're giving appropriate weight to a decision maker's opinion. They have to actually give the weight, and I know that this court will.
The rubric of margin of appreciation is most frequently deployed in the pan-European context. In cases like Kebeline, Lord Hope referred to it as an area of discretionary judgment, but it doesn't really matter what nomenclature one adopts. While, of course, you're right in submitting that weight has to be given to the decision maker, I mean, does that impinge directly on the court's obligation to examine the reasons to ensure that the response of the particular department is proportionate?
My lords, no, it doesn't. I accept that the court must examine the reasons. However, if the reasons include such things as the judgment of those who can be expected to have expertise in the area, then the judgment itself deserves weight. In my submission, it wouldn't be right for the court to say, in a case like this, we need a step-by-step description of numerous examples of how a fraud case might go and what sort of changes you'd have to make to stop it going in that way and what exactly those sort of changes would cost. My submission in the end is that the respondent does enough by candidly saying what its opinion is and giving proper reasons why it holds that opinion, including some practical detail of what it does operationally and of things like cost. There is a further point to make as well, which is that in addition to the respondents' views, we have the conclusions of two courts below, and they too deserve proper weight. And it's when one puts those things together, when one looks at the appeal and comes back in the end to the submission being made that because of the discomfort the appellant feels, they feel it would be better for the data to be masked, even though the respondent has given some reasons why it shouldn't be. What one ends up with is ultimately the sort of merits challenge, which in my submission, firstly, does not found a successful judicial review, and secondly, in a human rights context, shouldn't, on these facts, get past the margin of appreciation.
Wonder, I think the margin of appreciation is always quite a tricky one, because really the issue here, and it quite often happens in these judicial review cases that move up to the courts, and one loses track of what's evidence and what's submission. And you've shown us all these responses from the Secretary of State, and implicitly you're asking us, and probably rightly, to say, well, they are responses given not just by way of advocate's argument, but they're given with the benefit of the expertise that the department has, which includes people like Miss Tilley and Mr. James and others. And to that extent, we're giving weight really to the expertise which is behind them. Is that the way you put it? Or
well, Lord, I do put it in that way. I am, of course, aware that we are relying on arguments that have been put forward in a number of different ways as the case has evolved. My task might be a bit simpler if the original claim had said the data must be masked, and then I'd come along with a long witness statement containing all the things on which
but you are, in effect, asking us to treat those statements you referred us to, albeit in responses to letters and so on, as effectively evidence, and evidence supported by expertise.
My Lord, I am. And if there were a difficulty with that, I would retreat to this position, that, as I said yesterday, the court hasn't yet decided whether the appellant should be allowed to advance arguments about the legitimate aims which were abandoned below. And one of the reasons why one might not allow that is if there's an evidential prejudice to the respondent. If in the end all that we're missing was a document headed witness statement with a statement of truth at the bottom which said the contents of these documents are true, I am a DWP expert, well, my lady, my lords, that can be provided, and I have, of course, checked that it can be provided if required. So in my submission, if in the end the difficulty with my case is the status of the documents in which it's contained, then I submit that's a reflection of the fact that some of these issues have lain dormant for a long time and they've sprung up again now. Where we are left is that in response to a somewhat unparticularized suggestion that there should be masking, the respondent explains why the information needs to be visible to some users in some circumstances. And nobody has put before the court an alternative in which that could be done with significantly less intrusion into the appellant's rights. So when finally one comes to the overall balance part of the proportionality exercise...
Sorry, Mr. Bourne, you haven't actually, under the third inquiry, referred us orally to any authority on this question of respect for the width of the decision-maker's discretion. What's your best case on that?
Can I take a moment to retrieve that from the written case?
Yes, I mean, I've been obviously looking at paragraph 98, 99. I don't know whether that's where you think you located best.
There'll be something in misbehaving, won't there?
You get it in Huang, don't you?
You get it in Huang, yes.
And sort of probably in Quiller too, I wouldn't be surprised.
Yes, I mean, for example, I might need to take slightly longer to give a proper answer to the question, what's your best authority? But I would, if I may, point towards the reference in our footnote 70 on page 36 of the case. And that's in the context that I've just been dealing with, namely whether a less intrusive measure could have been used without unacceptably compromising the objective. And the reference to Lord Reid in Edwards' books, the courts are not called upon to substitute judicial opinions for legislative ones as to the place in which to draw a precise line. And of course, the fact that in almost every situation a judge could come up with something slightly less intrusive.
This is not really legislative, this is more administrative ones.
My lord, yes.
But I think there are plenty of statements about giving weight to the departmental expertise. I mean, Huang comes to mind.
Well, indeed, and if one goes on to paragraph 73 of the case, 73A, not a shift to merits review, reference in the footnote to AXA insurance, and 73B, weight will be afforded to the judgment of the person who has primary responsibility. And there we cite, indeed, misbehaving, as Lady Hale said, and Huang, as Lord Conworth said.
Well, thank you.
Are you coming back to universal credit, or is that?
I am indeed, my lord, yes. Thank you for reminding me.
No, I'm sure you won't. Go on.
When we come...
Well, you've not got very long.
Well, I haven't. I will be honest in a matter of seconds. When we come to the overall balance, interference on the one side or discriminatory effect, and benefits or aims on the other, one does, as I said earlier today, start with the extent of the interference, and I've made my submissions about that. In relation to that balance between, if you like, the bad and the good, in relation to the SCR policy, I would answer a question which my Lord Wilson put to Ms. Harrison yesterday by saying that whilst the SCR policy has pros and cons, it is not a net con. Another factor that is relevant is that, as the Court of Appeal recorded in its paragraph 61, the respondent has given considerable thought as to how the concerns of transgender customers can be accommodated. The detail is in paragraph 53 of our written case and in footnotes attached to it. We have run through all the references to various decision-making processes. And it's again, when you look at those processes, that the margin of appreciation has to be given a real meaning. The evidence doesn't show that the respondent's conclusions are wrong and doesn't provide a basis for substituting anyone else's judgment, or indeed a basis for finding that the Court of Appeal erred in dismissing the appeal for the reasons it gave. Finally, then, the appellant's new point about universal credit. In one sentence, we say that that contention misunderstands or fails to appreciate the information which has been supplied. And may I go back one final time to the note which we handed up this morning, where we seek to pull these strands together at our paragraph 15. Can I perhaps just give the court a minute to run your eyes over that paragraph rather than reading it? to summarise then, visible data are or may be used in both present and future systems and may need to be seen by someone. Biographical identity verification is currently done by frontline JCP officers. When we eventually get to Universal Credit full system, it'll be done by staff in a service centre in conjunction with job centre staff, but the job centre staff won't be accessing that verification data. But in the meantime, under the transitional UC Live service, those job centre staff retain access to CIS for this purpose. Under the full system, when it comes in, the person seeing the information will no longer be the official in the job centre, but will be on the end of a telephone at a service centre. What the Court of Appeal accepted, as a matter of fact, at its paragraph 61, was that data need to be available for identity verification. And the point is that that fact won't change, even though the mechanics of the verification will. And job centre advisors, keeping their eyes open, will still initiate fraud inquiries, but the resulting checks will be carried out by somebody else. It's not the case that the respondent has retreated from asserting a need for visible retention of data.
Yes, but its visibility is circumscribed. I mean, the appellant's case is, why not introduce a similar circumscription?
Well, the reason is that the respondent is moving as quickly as it can to move to these newer and, one hopes, generally more modern and better arrangements.
But is there any logistical reason that the same system could not be introduced for the present case?
Well, my lord, yes. The answer is that at the moment it is only the job centre staff that are in a position to perform that verification function. The process of changing it involves changing not only personnel arrangements, but also the underlying systems, and it's being done on a regional phased basis. It's not the policy of the respondent to delay that process at all. On the contrary, I'm sure the respondent is impatient to have it all in place. But I would like to emphasise that the shift to universal credit is a monumental change. I can't remember how many billions are involved, but at least one. 1.7, I'm obliged.
It's not uncontroversial.
Well, my lord, perhaps I shouldn't comment on that, but it's not
enough trouble without getting into the controversy prompted by universal credit.
It's not the sort of thing that can be done overnight. My lady, my lords, those are the reasons for which we say the appeal should not succeed. Can I just finish with a minute or so on the topic of relief, just in case the appellant does make headway on any of the various grounds? If any part of the appeal does succeed, then no doubt it would be reflected in some sort of declaration whether or not there was any other relief. I think it was in my learned friend's note last week that they indicated that they were asking for a mandatory order for masking. And what I was going to say was that if the appellant does win on anything, then we would request that there should be an opportunity for further submissions about relief after judgment once it's known what is in that judgment and what, if any, defect has been found and what its effect is. And of course, an important reason for that is that whatever might ultimately be identified as objectionable, there may be more than one way of remedying it. Remedying it might, as I've said, be difficult, even if the court eventually rules that it must be done. And of course, finally, it does sound very much as if the coming of universal credit is going to change this landscape anyway, and that might also be a reason to delve into relief rather more energetically once we know what, if anything, we're faced with. My lady, my lords, I don't know if I can assist any further.
It appears not, Mr. Bourne. Thank you very much indeed. Miss Emerson? Miss Harrison?
My Lords, can I deal first of all in reply with the submissions of Mr. Bourne about the taking of new points? And I'll deal very briefly with the discrimination, Article 3 and harassment, because we have addressed that already in our note. And so it would only be repeating those. The critical issue that was identified by Mr. Bourne in respect of the claim based on harassment was that, but that was the only claim where it was suggested that there was prejudice to the respondent in responding to it. And as we set out in our reply at 26 to 28, we don't accept that because the fundamental basis upon which we say these statutory test for harassment in section 26 of the Equality Act was met is based upon uncontested findings of fact by the courts below that the experience of my client in accessing her entitlement to benefit caused her distress and humiliation when she had direct contact with frontline officials who knew of her gender history. So it's the distress, which was also described by the Court of Appeal 57 as deep distress, and humiliation that is the basis of that claim. That doesn't require any further findings of fact to be made. That's the critical basis upon which it's put. We would also note that insofar as the complaint is based upon more overt and derogatory comments relating to the individual's transgender status, that was also the subject of an actually investigated complaint that was upheld. And the reference for that is at 2851 MS 5379, and it was in respect of that complaint that she received compensation for distress. So there is a proper evidential basis for concluding that, A, this was unwanted conduct.
Sorry, could you give me the reference again?
Yes, it's 2851 MS 5379, that's the complaint, and the response 2855 MS 583.
Okay.
Would you give me the MS number again, please?
Sorry, MS 583.
5-8?
That doesn't sound right.
No.
That doesn't sound right.
Sorry, we'll come back and give you the exact reference in a moment. Will you just give me that a moment? But the fundamental submission that we make about that is that there is no prejudice to the claimant to the respondent in that regard, and therefore the objection to that matter being considered by the court should not follow through. Perhaps of more critical consequence in respect of the Article 8 claim is the respondent's suggestion that a concession that was made in the court below in respect of the rational connection to the legitimate aims has been withdrawn. And we submit that that is an incorrect description of what happened below, because it's quite clear if one looks at the statement of facts and issues where this matter was specifically addressed at paragraph 48.1, and that's CV6 MS 4194, it makes clear that the rational connection was in fact argued before the court below. It was also included in the skeleton argument at paragraph 19.1 and 4, reference 2R166 MS 6194. And it is obviously important because it's part of Mr. Bourne's explanation as to why the court's analysis of rational connection is as cursory and as limited as it is, and doesn't meet, we respectfully submit, the exacting standards of analysis that are required. It isn't because rational connection wasn't argued, contrary to his submission. It's simply because the court's approach to that part of the case, a critical part of the case, was inadequate. And, we would further respectfully submit that it isn't just that the exacting analysis relates only to the question of whether the legitimate aim has a rational.
I mean, sorry, are you saying that Lord Justice Elias got it wrong in paragraph 55?
Yes, and that we sought to address that in the Statement of Facts and Issues, which is why 48.1 CV6 says that rational connection was argued. So we had thought that this had been resolved in the Statement of Facts and Issues.
I see. Well, I hadn't picked that up.
Yes.
So that was meant to correct that.
That was the agreed position in the Statement of Facts and Issues, that was a live issue before the court. Right. And as I said, you can look back to the skeleton argument.
Yes, and Miss McCann was there, so she can probably confirm.
Yes. We were surprised that was being maintained because of what's in the statement.
You were surprised by what Lord Justice Elias said then?
Well, that also, and which is why we sought to ensure that when we got to this position, that was properly clarified by the Statement of Facts and Issues. But in any event, to this extent, the requirement for exacting analysis of the factual case advanced is not limited to whether or not the aims have a rational connection to the means. It's absolutely plain that applies to each aspect of the four-stage test of proportionality in whichever case one seeks its source from. It's in each respect that rigorous, anxious scrutiny and investigation of the justification for the measures taken must be undertaken. And so we respectfully submit that my learned friend's submission that you don't find that in the Court of Appeal's judgment because it's based upon a concession, which is wrong, is highly material to how the court ought to look at the way in which the Court of Appeal addressed it below, and it's why we say this is an appropriate case in which this court must readdress all those matters on the material that's now before them. The second issue in respect of the approach to the case below and the arguments that have been advanced, which is of significance, is my learned friend's suggestion that it has not been part of the claimant's case from the outset to challenge visible retention of the historic gender identity data. And that's simply also not correct. If I could give you the references in the first instance skeleton, I hope these are going to be correct. It's 96.4 and 96.6 is the paragraph, and that's MS 4710. 104 relates to the argument as to the masking option. That's
Sorry,
MS
47104.
4710, my lord.
4710.
Yes. And the masking option MS 4715. And in the Court of Appeal skeleton, it's paragraph 18, MS 6192, 19.2, that's MS 6194, and 22, MS 6195. So it has always been a part of the claimant's case challenging the visible retention of the material. What one has to recognise is that at the first instance, the visible retention of information also included the GRC certificate itself. So to that extent, focus on the subsidiary material, the gender identity data, wasn't at the forefront of the argument because the GRC field was on the frontline computer screen and was popped up immediately. So insofar as there's been any change in case, it has been because the respondent subsequently, as we know, accepted that it could in fact mask the GRC information. But why that's important for this court's assessment of the case is because, again, it's my learned friend's submission that the way in which the evidence is before the court is a reflection of how the case was argued below. And we respectfully submit that that is not a fair and accurate description of the explanation for the focus of the evidence in the actual witness statements. And our submissions that we made yesterday about the way in which the respondent's case on justification has varied and changed over time is properly made and does cast real doubt about its efficacy when properly subject to an exacting analysis of what it is. And so it can't be explained, as Malone and Friend sought to do, by the way in which this case has developed over time. And we say it remains critically important that the only direct witness evidence that was produced in respect of the justification for visible retention on the CIS of the gender history data for fraud purposes is Mr. James, and he simply does not make out that case. He focuses upon retention.
Do you accept, do you, that where we can take into account the responses to the later questions that Mr. Bourne has relied on as representing the considered view of the department with the benefit of their expertise?
Well, what we say about that is that the considered view of the Secretary of State, the department, has changed, and it's changed because of the way in which the arguments have developed in the courts. That's the proper way of looking at it, because Mr. James...
But I mean, that's what I'm asking, is where we've got to, forget about how we've got there, whether we're entitled to take the evidence, the material we presented by way of responses as representing the present considered view of the Secretary of State with the benefit of her expertise, his expertise.
What we say about that is it is significant that this position wasn't put forward at the outset, because visible retention was clearly an issue.
What do we do about it? Are you saying we disbelieve it for that reason, or do we accept it?
I think what you'd say is that we are entitled, indeed required, to look at the evidence, but we should do so with against the backdrop that this has been a changing scenes, should I put it that way?
Yes, and that therefore does mean that the deference to which the court is going to afford to this material is affected, and it does clearly undermine, we respectfully submit, its cogency. And
forgive me, look at the note that came this morning.
Yes.
Paragraph 12 and 13 are the bits that we're being taken to. They're extracts, and there's more in the answers to the Part 18 requests, but that's...
Yes.
These illustrate the point. Are you asking us to doubt what is said in those italicised quotations or not?
What my submission is that I'm asking you not to afford deference to it.
Never mind whether we afford deference to it. Do you doubt it factually?
On the basis of the information on the basis of the opportunity that we've had so far to view this, the points that I would make about the material, for example, is that, and if we could just take up MS page 5331.
Yeah.
Which is 803. C135.
Sorry, C1...
35.
C135.
Yes, my lord. That's 5331.
Yep.
The first observation that we would make about that is that it's the last two paragraphs, that having immediate access via SIS to historic information relating to the name data is a key part of the verification of the claims. However, the observation that we would make about that is that, and we explored it briefly yesterday, is that no frontline staff has immediate access to the SIS because of the SCR in this context. And it inevitably involves delay, as we know, in someone being authorised to have access to it. So that would be one observation we'd make about the reference to immediate access. What and that would obviously accord with the evidence that my learned friend relies upon about the lack of routine access to the SIS, and it also accords with what was provided in answer to my Lord Hughes' question yesterday about access when it comes to new claims, that ordinarily they wouldn't have access to the historical data on the JSAPs.
Not routinely for every new claim, exactly.
Yes, yes. So one can't just immediately take this evidence, which is in the pleading, at face value. The other point that we would make at this stage is that when one looks at the second paragraph, further without access to historical name details on the SIS, the volume of suspicious cases referrals would grow significantly as frontline staff would not be able to verify identity. And just to remind the court that when we looked at Mr. James's evidence yesterday in paragraph 18, his view was not that it was the historic name details that was necessary, rather it was the GRC and the SCR that was significant in being able to either alert or resolve fraud concerns. So there is a significant inconsistency in the evidence in the actual evidence before the court and in these responses to the Part 18 request, which again we respectfully submit does undermine the efficacy of this material and its proper basis for concluding that the intrusions into my client's fundamental rights was justified. And following that through, we do say that the court must take into account the material that is now available as to the proposed changes and the implementation of those changes to universal credit, because we do submit that there's nothing in this note that undermines what was said in paragraph 97 of my learned friend's skeleton argument, that it has now been assessed that it is not necessary for frontline staff either to have access to the historic gender data, nor for there therefore to be an SCR. Now, the learned friend says that there'll be a different system, and that system will involve others who are not frontline staff having access to this material. But we say that precisely illustrates the point. As we have always said, there was a less intrusive measure that was capable of meeting the respondents' legitimate aims. If that is the case, we submit, then the practicalities of belatedly seeking to implement it and the costs of doing so are not sufficient to conclude that that less intrusive measure shouldn't have been identified and taken many years ago. As we are aware, this claim has been ongoing since 2010, and there was correspondence going back to, since 2012, and there was correspondence going back to 2010. And so we submit that that fact that the system is intended and is being changed doesn't undermine the critical inference to be drawn from that recognition that there is, in fact, a less intrusive measure available that would not have had the significant, and we respectfully submit, serious consequences on my client's fundamental rights, denying her a congruent gender identity and subjecting her to treatment that it's found below caused both distress and humiliation. If I can, in light of that submission, deal with the question of what weight and deference is to be placed on the Secretary of State's justifications. The court asked my learned friend which authority is relied upon to support the proposition that in a choice of administrative policy, operational measure, the court will afford a significant degree of deference. And we respectfully submit that when one considers the case law that has been relied upon by my learned friend, that the overwhelming reference, the cases have focused not on administrative policy, but upon legislative choices, and that inevitably, in the institutional balance between the courts and the democratic government, that is going to afford an area of discretion for the legislature. This is not in that category of case. This is a case concerned with, as is obviously my learned friend's acceptance, it's an administrative choice, an operational measure that does not fall into the category of situation where the courts will afford deference to a decision maker.
But there are loads of cases involving administrative decisions where the courts have said. In Huang, it was said the word deference was the wrong word, just as margin of appreciation is not quite the right concept. It's basically giving appropriate weight to the relative institutional competence of the people making the decisions. I'm just looking at Huang now. The giving of weight to factors such as these, which is in an immigration context, is not, in our opinion, aptly described as deference. It is the performance of the ordinary judicial task of weighing up the competing considerations on each side and according appropriate weight to the judgment of a person with responsibility for a given subject matter and access to special sources of knowledge and advice. This is how any rational judicial decision maker is likely to proceed. Paragraph 16 of Huang in the House of Lords. That's what you had in mind, I think, Lord Carter.
Yes. Thank you.
Well, obviously, it will that will always depend upon the precise context. And in immigration matters, then clearly the courts have afforded that degree of deference to the Secretary of State for the Home Department in the context, particularly where specific rules have been implemented to indicate what Parliament's view is about the weighing of the balance.
That's not what that was about at all. It was about making a judgment in an individual case.
What we respectfully submit is that where you have an administrative policy that directly impacts upon a core aspect of a fundamental human right, and where the European Court of Human Rights in Goodwin has emphasised in particular in assessing the question of the Article 8(1) interference, is there a coherence between the legislative and administrative systems? That has been precisely an area where the European Court did not afford a significant margin. In fact, it concluded that in precisely that context, where there was disjuncture between legal and social gender identity, administrative policies and institutional views about the significance and the consequences of change of birth certificate were not held to be sufficient to justify the clear intrusion into the fundamental rights of individuals. And we say that that is important when one is considering this precise context, because that has been identified by Strasbourg in both Goodwin and the subsequent case that I'd showed the court, Hamelin, as being of importance in judging whether or not there has been respect for an interference with Article 8(1). So we are in a very particular category of case, and we would respectfully submit that whilst the court will obviously have regard to what the justification is on behalf of the respondent, it will have to, in particular, subject that not to deference, but to exacting accountability, because it's precisely in the area of concern where administrative practices now, ironically, are the source of the conflict and incongruence in gender identity, as opposed to the situation pre-Goodwin, where it was the lack of legal recognition that caused the discordance and conflict between the individual's social gender and their legal gender. And in those circumstances, we respectfully submit that this is an area where, at the very least, the court, if it's going to give significant deference or to accept the institutional competence of the respondent, it must have before it a proper evidential basis that, when subject to the sort of exacting factual analysis that's required, it stands up. And in those circumstances, we respectfully submit that the court should not, as my learned friend suggests, allow their institutional expertise to override what is, we respectfully submit, clearly an inadequate factual basis for the assertions that they make about, A, the necessity of this measure, and in particular, why alternatives were not sufficient to meet the aims and the concerns of those decision makers. Ultimately, as is clear from cases such as when it comes to striking the balance, that is not an area where the court affords deference to decision makers. That is a matter for the court. And in that respect, we submit that this is not a situation where you're in any different a position to the courts below. It wasn't a case that turns upon any factual findings based on assessment of credibility or any other matter such as that. This is a situation where this court is in as good a position as the Court of Appeal. And we say that when you do apply the fourth criteria to this circumstances, it is evident that the benefit to the respondent of maintaining visibly the gender identity data does not outweigh the very serious intrusion on fundamental rights. And in that regard, if I can deal with my learned friend's submissions about the way in which to characterize the Article 8.1 interference, which is to describe it as limited, not minor, but limited, we say that that is it does not properly have regard to, A, the evidence below as to the nature of the interference, and does seek to airbrush out the findings, A, of distress and humiliation in paragraph 57, arising from direct contact with officials who are aware of the gender history, and B, the findings of Simon J, paragraph 96, and the court at 69, the court below 69, that the SCR policy, whether alone or in combination with the retention policy, result in the individual's gender status, transgender status being disclosed or identified. And it is still a critical part of the respondent's defence to have to assert that no such finding was made, and to have no regard to the conclusion, in particular at paragraph 57, that there clearly have been occasions when her gender history has been known to frontline staff. It has not been known for any purpose connected either to pensions or to fraud. It's been in the ordinary exchange relevant to the claim for JSA benefits and not at all related to any of those aims that are relied upon by the Secretary of State. And in those circumstances, we submit that does mean that the operation or the effect of these policies in combination engages the very core and fundamental aspect of her right to a congruent gender identity, which is not to be categorised properly on the basis of either Goodwin or the approach of the court in MARPA as a limited interference. It is a profound and significant interference, and the failure to acknowledge that, both the respondent itself in how it has assessed its responsibilities and balance the interests, is obviously flawed, and we have respectfully submitted that it also failed to be properly analysed in the courts below, with the resulting failure to recognise the very much more limited scope of any deference or margin, and the more exacting standards that were required of the justification for the interference. That then leads me to the submissions on the GRA, and what we say in respect of the Gender Recognition Act is that it is not part of our case that the respondent cannot retain and hold information relating to the gender history and also to the change of gender. Our complaint is that it must only be disclosed in circumstances where it is necessary for an identified purpose, and that if there is a situation, as we submit is the case here, where it is being disclosed for other purposes, obviously in this context relating to the claim for job seekers allowance, that is not compatible with the obligations in Article 9, in Section 9 of the GRA, and that where a public authority is faced with a situation of properly holding the material, it has to make a decision that takes into account the fundamental proposition of the Gender Recognition Act in Section 9.1, that it has a duty, current and prospective, whatever the past gender status, to accord full recognition to the change in gender. And whereas here we respectfully submit there was a choice between an administrative policy that could have ensured and protected disclosure of the change of gender, Section 9.1 mandates that that be taken. The alternative consequence is that the retention of the historical data is allowed to operate to undermine the fundamental principle in 9.1. And we say that is clearly contrary to the fundamental purpose of this legislation. And that the exceptions to criminal offences in paragraph 22 is not a carte blanche or a legal mandate for disclosure of the gender identity, the past gender identity and the fact of a reassignment in circumstances where it simply is not necessary for any identifiable exception. So, of course, my learned friend properly referred you to the two exceptions that there are to criminal offences in F and H. But what he didn't acknowledge is that in this context and on the findings of fact in respect of my individual client, her gender identity, past gender identity, has become known and disclosed to officials and others, not for any identifiable purpose that would be exempted under the GRA in section 22. To the contrary, it has been disclosed to officials and and others, because obviously one of the complaints was the security guard had made reference to transgender status. And in those circumstances, one cannot pray in aid very broad exemptions to a criminal offence to justify undermining the core purpose of this legislation, which was to secure for my client treatment as a woman, not as a person who has changed sex or changed gender or had a previous gender. And so we say, for that reason, the indiscriminate and arbitrary retention visibly of the information does infringe the overriding principle in section 9 of the GRA. We would also make the observation that it's that critical failure to recognise that consequence of the operation of the respondent's policy, namely that it does reveal and draw attention to the gender status, that flaws the respondent's submissions on the discrimination claim. And we say that once that's recognised, as it clearly should be, that those whose change of identity data is held includes those whose change is based on gender reassignment, it's quite clear that they are in a different category to others who've changed their identity details for other reasons. And that we do respectfully submit that, contrary to the submissions that my learned friend makes, properly applying the voluminous principle, that would make a difference to the approach that should have been taken by the court below. And that critical difference is that it's not the justification for the overriding measure that is required to be the focus of the analysis, but instead must include the justification for failing to meet the different needs of the transgender customer, rather than applying a blanket policy across the board. It is necessary to justify why it is that you didn't treat them differently to take account of their very different needs in the application of this policy, and which essentially would mean making an exception to the general rule by masking data that revealed the change of gender, and that can include, as we know from cases such as Burnip, which is volume 10, tab 85, MS 3028, that can also include allocating additional resources to meet particular needs. Obviously, that was in the context of needs of disabled people for additional living space. But it is quite clear when one analyses the authorities that the fact that the overriding measure is justified has not meant that where you can identify a significant difference and a particular need of individuals, that the failure to meet that will be justified by the same overriding explanation for the policy. And so we do say properly analysed, and once it's accepted that these are not individuals that should be treated like others who have a change of identity data, there was both a failure to make a specific measure to address their needs, and we would also submit that it resulted in particular disadvantage based upon there being obviously a very significantly greater proportion of transgender people who make up those who are subject to the SCR policy and all its attendant problems in terms of delay, disadvantage, as well as the very particular problem that it presents to those who are transgender, namely revealing or drawing attention to their status. And we respectfully submit that it isn't correct to suggest that it would have made no difference to the analysis had there been, as we say there should have been, proper recognition, either that this policy didn't treat transgender as insignificantly different, or alternatively, the policy having a particular disadvantage to that group. Finally, in respect of the direct discrimination, our submission is a simple one, and it is that in selecting the criteria of visibly retaining change of identity details, that intrinsically and inherently resulted in less favourable treatment or a greater risk of less favourable treatment for transgender customers. That being, as we've said, the impact on their gender identity, the distress and humiliation that they experienced of being treated by staff who are aware of their gender history. And the question of whether or not there's an appropriate comparator, we respectfully submit that this is a case analogous to pregnancy, that we are concerned with a unique characteristic dependent on gender reassignment, i.e. that the individual has undergone a change to their gender as the explanation for why the data is different. And that does put them in a particular unique category. And for those reasons, we say that the Court A should entertain the discrimination claim, the direct discrimination claim, and also find that it's made out. My lords, my lady, unless I can assist you further, those are my submissions.
And just quickly, one of the points that's made against you is to distinguish between the SCR
Yes.
and its effects, which are admitted to cause problems anyway, and but what's said there is you could opt out of that, and then one would be back on the ordinary system of JSAPS and CIS. Do we have evidence from your client as to what her objections would be to going back to that system? I mean, just point me to the evidence. I'm not asking.
We do. I'll give you the reference, but essentially the way that we put that in our case is that that puts her on a Morton's fork, so that she either has to experience the difficulties of being identified as transgender in the way that we said, or she has to have the possibility of her gender identity history being available to...
Yes, I was just wondering where, if you give me the reference to where that point is made out in the evidence. Well, never mind now, but...
What's important about that is that Mr. Justice Simon did not think that that was an option.
Yeah.
And it would be wrong to treat that as a choice, given what it's a choice between.
Thank you.
And the reference in the evidence is to 2B 308.
Thank you.
That's B114. And the MS reference is 4836.
Thank you.
Yeah, and there is also the point that you do have the evidence of CP, which you,
yes, I referred to that.
where, as to what are the consequences of not being subject to an SCR.
Thank you.
And could I just give you the correct reference with regards to the harassment complaint?
I think that was 5583.
It was.
Found it.
Thank you very much.
Thank you. Well, thank you all very much indeed for all your arguments, both in writing and orally. So we're thanking the people who I'm sure helped in the preparation of the written arguments, as well as those from whom we've had the privilege of hearing in the course of this day and a half. We will now go away and try and work out what the answer is, and we will let you know in the usual fashion. And I hope that your client has found it possible to watch the hearing and feel that she has been part of it.
I think that she definitely has. Could I just make this one observation, which I've had a note, which is that because we received the respondent's note this morning on the evidential matters, that if there was anything in addition that we want to put before the court, obviously I was responding on the hoof in the way that you saw,
yes.
If we could have the opportunity to do that.
Yes, please, but perhaps within 7 days.
Of course, yes.
Thank you. Court is now adjourned.